In today's explosive courtroom drama, tensions reach a boiling point as a mother's repeated defiance of court orders leads to serious consequences. What started as a custody dispute turns into a stunning legal showdown when she refuses, again and again, to allow her ex-husband his court-ordered parenting time. Despite multiple investigations by Child Protective Services and law enforcement finding no evidence to support her allegations, she continues to make claims and withhold the children. The judge carefully reviews the history of the case, pointing out a clear pattern of non-compliance. Time after time, the father showed up for scheduled pickups, sometimes even with police present, only to be turned away. Doors were slammed, calls were ignored, and court orders were disregarded. Inside the courtroom, emotions run high as the mother attempts to justify her actions, but when pressed for evidence, she cannot provide factual proof to support her accusations. As the hearing unfolds, the judge makes it clear that the courtroom is governed by law, not emotion. The well-being of the children and the integrity of the judicial system are at stake. After reviewing the documented violations, the judge finds her in contempt of court and sentences her to 30 days in jail, ordering that she remain there until the children are turned over and outstanding legal fees are paid. But the drama doesn't stop there. Her continued interruptions and defiant remarks in court only make matters worse, leading to an additional 30 days, bringing the total to 60 days behind bars. The ruling sends a powerful message: court orders are not optional, and using children as leverage in custody battles carries serious consequences. This shocking hearing serves as a reminder that in family court, actions speak louder than words, and accountability always comes due.
Parenting time. I'll let you know we're going to take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak, so don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection that focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it, which leads me also to the moral fitness of the parties involved, which ties into the same factor. We have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo, we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved as well. as the stable, satisfactory environment, in that she's accusing him of sex with girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not going to facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done. The statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. That's also false. I was never told that they were declining to investigate the police. Number 8, it's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support, and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions, regardless of stature or representation. That's all.
okay, thank you. I don't need anything else, Mr. Kelly. What the court will do in this matter is the court has read the pleadings, obviously you're well aware of the file in this case. The court does believe that the plaintiff has met the Vavarka threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client?
Right.
Okay, Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure. We'll keep it straight and to the point here. Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make-up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make-up parenting time?
yes.
What happened?
She refused to give them to me.
As you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make-up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No?
How do you know Mr. Connolly?
He is my son.
You heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop-offs for
I
parenting
do.
time? Has there been occasions when you have gone with him to go get the girls and anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park and we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls. His first visit that he was supposed to was I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was going to refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted. That help in terms of actually getting parenting time to occur?
No, she just did the same thing to the police.
Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time that stated that the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
And you don't remember if she was not there or if she refused?
I don't remember that specific time.
Okay.
I have it written down at home, but I don't remember.
Okay. Ms. Couch, do you have any questions
I
of
do,
this witness?
yes. At what age did Zach Conley start wearing diapers?
Judge, I'm gonna object to it.
Ma'am, that is not germane.
No, I am.
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, etc. Okay?
Okay.
Go ahead.
And you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes. Or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Even though the order was for the 29th. Wasn't that the
Whatever,
order that the judge put
whatever
in
day,
place?
whatever judgment day,
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because was that an appointment that
And,
you slammed the door in my face? I have it on video, yes.
and you came alone, correct?
I did that day,
Okay.
yes.
That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witnesses? No? Okay. Check that order because there was some, Ms. Couch, you raised some issues concerning the, I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups
And why is that?
because he our children, and I don't believe that he needs any more parenting time.
Okay. You understand that there's an order for parenting time.
And if it was your children, you would be sending them with him.
Yeah, I'm just asking you a question. You understand that it was parenting, that it was ordered,
Didn't you deny that? Didn't you go on base and deny it after the fact?
not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that.
You guys did receive the pictures that I submitted to the court as well, correct?
Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the middle.
Today's courtroom drama is intense, emotional, and shocking, as we witness a mother, referred to as Karen, face the consequences of repeatedly defying court orders. For months, she refused to allow her ex-husband, Mr. Connolly, to spend time with their children, ignoring legal mandates and disregarding the impact her actions had on everyone involved. This isn't just a story about a custody dispute. It's a story about accountability, consequences, and the limits of parental authority when the law intervenes. Karen's history with the courts is long and complicated. She repeatedly made serious allegations against Mr. Connolly, accusing him of misconduct toward their children. These claims triggered investigations by Child Protective Services and local law enforcement, but each time, authorities found no evidence to support her accusations. Despite the investigations clearing him, Karen continued to act as though the allegations were true, refusing to comply with court orders and denying her ex-husband access to his own children. Every missed visit, every closed door, every ignored call added tension to an already volatile situation. The courtroom was about to see the culmination of this ongoing defiance. When the hearing began, the atmosphere was thick with emotion. Karen appeared visibly frustrated and defensive, speaking passionately and at times aggressively. She tried to justify her decisions, explaining her fears and concerns, but when pressed for factual evidence, she had none. The judge listened patiently, reviewing the documented history of non-compliance, the denied allegations, and the repeated missed parenting appointments. The pattern was clear. Karen's behavior was not occasional or accidental, it was deliberate and ongoing. The children had been caught in the middle of this conflict, and the court could not ignore the negative impact on them. As the hearing continued, the judge emphasized that the courtroom is not a place for emotion or manipulation, it is a place for law, fairness, and the protection of children's best interests. Karen's actions had crossed a line. Repeatedly refusing to comply with parenting orders, making baseless allegations, and obstructing lawful visitation had left the court with no choice. After reviewing all the evidence, the judge held her in contempt of court. She was sentenced to 30 days in jail, with clear instructions that she would remain in custody until she complied with the court's orders, returned the children to their father, and settled outstanding attorney fees. The ruling sent a powerful message about accountability and the importance of following the law. Even after the initial ruling, Karen's behavior continued to escalate. During the hearing, she made inappropriate remarks and challenged the authority of the court itself. She seemed unwilling to acknowledge the seriousness of her actions, showing defiance in the face of clear legal directives. The judge, however, remained firm. The court cannot tolerate repeated disrespect, obstruction, or manipulation, especially when the well-being of children is at stake. For her continued defiance, the judge imposed an additional 30-day contempt charge, bringing her total sentence to 60 days in jail. The ruling was unprecedented in its clarity. Attempts to manipulate the legal system using children as leverage would not be tolerated. This case highlights the broader impact of parental defiance in custody disputes. Children are not objects to be used as bargaining tools. They are human beings whose emotional and psychological well-being must be prioritized. Mr. Connolly's repeated efforts to maintain a relationship with his children were continually blocked, causing unnecessary stress and emotional harm to everyone involved. The courtroom proceedings reveal how one parent's refusal to comply with legal obligations can disrupt the lives of an entire family. The judge's ruling underscores the principle that children's rights are paramount and that parents must respect legal boundaries for the sake of those they claim to love. Throughout the hearing, the tension between Karen and the court was palpable. Every word she spoke, every objection she raised, seemed to heighten the drama, but it also highlighted the importance of the law. The judge's careful attention to detail, understanding of precedent, and focus on protecting the children's best interests ensured that justice would prevail. Karen's inability to produce evidence, her reliance on emotional appeals, and her repeated attempts to deflect responsibility only reinforced the court's decision. Accountability is not optional, and the legal system exists to enforce compliance when personal emotions threaten the welfare of children. The consequences of this case are far-reaching. Karen's 60-day sentence serves as a stark warning to others who might consider using children as pawns in legal disputes. Court orders exist for a reason, and failing to comply carries serious repercussions. The judge's decision also reinforces the idea that family courts are designed to protect children first and foremost, not to serve as a battleground for adult egos or grievances. This hearing is a reminder that parental authority is not absolute. It is constrained by law, ethics, and the responsibility to act in the best interest of the child. As the hearing concluded, it became clear that the court's role is not to punish out of spite but to enforce rules and protect those who cannot protect themselves. Karen's actions had repeatedly undermined the legal process, endangered the emotional stability of her children, and caused significant strain on her ex-husband. The judge's ruling addressed each of these issues directly, ensuring that the children would now have the opportunity to spend time with their father as the law intended. It was a decisive moment of justice, one that will likely be referenced in future custody cases as an example of how the courts handle deliberate obstruction. This courtroom drama also illustrates the broader principle that actions have consequences. Parents who rely on manipulation, false claims, or defiance of legal mandates risk far more than legal penalties. They risk the trust, stability, and emotional security of their children. In this case, the law acted as a corrective force, ensuring that the father's rights were upheld and that the children could finally experience the consistency and care they deserve. It is a powerful lesson about the importance of respecting court orders and the serious impact of defiance on real lives. The hearing stands as a cautionary tale, demonstrating the intersection of law, family, and accountability. Karen's emotional appeals could not outweigh the documented facts, the court's authority, or the best interests of the children. The judge's firm yet fair approach shows that while emotions run high in family disputes, the legal system has mechanisms to protect the vulnerable and enforce compliance. For anyone watching, the takeaway is clear: the law matters, and it is enforced when necessary to protect those who need it most. Ultimately, this case underscores a timeless truth: no parent, regardless of their intentions, is above the law. Court orders exist to safeguard rights, ensure fairness, and protect children. When these orders are ignored or challenged without justification, the consequences are real, tangible, and sometimes severe. Karen's 60-day sentence is not just a punishment, it is a statement about the importance of accountability, respect, and the rule of law in family court. This dramatic, emotional, and shocking hearing will be remembered as a powerful reminder of how seriously the courts take parental defiance, the protection of children, and the enforcement of justice.
The order is dated February 4, 2025, and it provided for make-up parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay. Let me clarify that, because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with a therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not, but you've not introduced that today, and you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter. So, okay, Mr. Kelly, do you have any final argument in this matter?
As the court's already touched on a little bit, this is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. with a threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from this couch. We request that the children be turned over to him today, that he have custody and parenting time with the children until the evidentiary hearing occurs. We request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's a voice she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time, 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank you.
Thank you. Ms. Couch, your closing argument.
I am acting I just want my kids to be safe.
Well, the court has heard again, the testimony in this case. The court will note that, again, that apparently there had been a denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has in fact denied parenting time, and court notes that as a result, she has withheld the children, that she's failed to comply with the order of.
But there's reason, sir.
Excuse me?
There's reason.
Okay.
Valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify, you had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025, that all four of those orders she's failed to comply with. The court has reviewed the file. There's been multiple show cause hearings. She has previously been held in contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note that I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time, and that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact she is ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until such time as you've paid the previously ordered attorney fees of $1,000. So, ma'am, you can go with the sheriff, and
Are you serious?
this matter is concluded. You're free to go.
Who's sucking whose dick around here?
Oh,
No,
ma'am,
seriously.
another 30 days for contempt of court. You're in jail for 60 days now.
No, what's going
If you
on?
keep going, I can go as long as you want, ma'am.